So in this particular video, we'll be talking about how to draft a contested divorce petition. But before delving into how it's drafted, I want to first touch upon the basics of it. So this session will be divided into three parts. First, we'll be talking about the foundation of divorces, what's the procedure, what are the legal provisions which are involved in it. In the second part, I'll take a template wherein so it's an easier version of how an actual divorce petition looks like. In that, I'll be explaining you how to go ahead with drafting of a divorce petition. And in the third part of this video, we'll be discussing an actual template. We'll be discussing an actual divorce petition which was drafted. So stay till the end. First, we'll be understanding about a bit about divorce, how cruelty is used as a ground of divorce, the ancillary reliefs, jurisdiction, etc., etc. So let's get started. First, I want to talk about divorce. So, whenever we are referring to any definition part, we always cite Blacklaw's dictionary or any concrete or recognized dictionary or place from which the definition has been taken should be used. So, in this case, I'm using Blacklaw's dictionary. So, divorce is basically legal dissolution of a marriage by court, or basically it's by any competent authority which is authorized to do so. So it's a formal ending of marriage through legal proceedings resulting in termination of marital relationship. I hope the definition is clear. Definition is pretty much self-explanatory. Now we'll be talking a bit about the provisions in the Hindu Marriage Act which are related in this case. So, first, you need to make sure that your marriage fulfills the conditions of the acts. In this particular scenario, we'll be referring to Hindu Marriage Act. So, Section 5 talks about the various conditions that are essential for Hindu marriage, like neither of the parties should have a living spouse at that particular time of marriage. Both the parties should be capable, should not be insane, should particularly fulfill that threshold, that age criteria which has been mentioned. So you can pause the video, you can refer and read to this section. I'll just very briefly touch upon the legal provisions. You can pause and read them in detail. Now, as per Section 7, the Hindu marriage, now I'm referring to this section, you'll realize when we'll go back to the template. When we'll go to the template, you'll realize that why I talked about this section. So, Section 7 basically talks about that Hindu marriage should be fulfilled and solemnized according to the customary rites and ceremonies. Now, skipping to directly Section 13. So, Section 13(1)(IA) of the Hindu Marriage Act discusses about cruelty as a ground of divorce. So, Section 13 talks about divorce, contested divorce, and Section 13B talks about mutual divorce. In this particular video, we'll only be dealing with Section 13 1IA because we'll be talking about cruelty particularly as a ground of divorce. So, taking you to Section 13, now you can pause and read it in detail, but I'll be quickly touching upon the essentials of it. Now, while drafting a divorce petition, you can use all of these grounds which are mentioned here. Just have a look at my cursor. You can mention one or more grounds of divorce, but in the present video we'll only be talking about cruelty as a ground of divorce. So this particular section is relevant for us, that after solemnization of marriage, if petitioner is treated with cruelty, the petitioner can move to the court and present a petition. Now, either party can do so, either the husband or wife, and seek for dissolution of marriage by decree of divorce. Now, you need to have a ground of divorce, at least one ground of divorce, and you need to have valid proof also attached to it. So, make sure your proof part is in hand, it's ready. Now, I'll also be discussing about cruelty as a ground of divorce. So, just this much is mentioned in the Act, but with the help of various landmark judgments, we also do have a lot of interpretation which has been done to the word cruelty. So earlier it wasn't a ground for divorce, but through an amendment it came into force. And cruelty is not just limited to physical cruelty. It comprises of mental, emotional, all sorts of things. So while drafting the petition, I'll deal more with cruelty as a ground. But there are other grounds too, like there's adultery, there's desertion. Just look here, so many grounds are mentioned, like conversion into another religion, mental disorder or unsound mind, incurable diseases that have been caused, or venereal diseases. So that's covered. And then renunciation of word or presumption of death. Now I'll quickly take you to section, just a second. To section 13b. So divorce by mutual consent is also a ground. You can look here, you can read it, pause it and read it. We'll not be dealing with divorce by mutual consent right now, but we'll be dealing with it in probably upcoming sessions. So right now we are only concerned with contested divorce petition. I'm just telling it to you for your reference purpose. Now bringing you to section 14. And section 14 states that no petition for divorce to be presented within 1 year of marriage until and unless it's become impossible to live with the petitioner. So you are encountering exceptional hardships or exceptional depravity on the part of respondent, then the court might entertain it. But if that's not the case, then court will not entertain any contested divorce petition before 1 year of marriage. Now, the documents that are required for filing of divorce petition are address proof of husband and wife, photographs of marriage between husband and wife, certificate of marriage, then evidence supporting the ground, or if you're taking one or more grounds, then the grounds of divorce, then professional and financial proofs of asset distribution for purposes of maintenance and alimony, and details of children if there's a child and there's an issue of child custody involved. Now we'll be talking about the jurisdiction part. So I'll bring you to directly to section number 19. Now you can, again, I'm saying you can pause and read it, but I'll quickly touch upon the important part of it. So the petition can be filed before the family court where marriage was solemnized. The respondent resides at the time of filing the petition, or at the place where the couple resided together last, or where the petitioner resides if the respondent is abroad or untraceable. So these are all the places where you can file your petition. So I'm just going to repeat it for your sake. The place where marriage was solemnized, the place where respondent resides at the time of filing, the place where couple resided last together, or the place where petitioner resided. So all of these are the places where divorce petition can be filed. Make sure you're filing it in the right court, and you're properly mentioning the content also. So the content has to be correct and without collusion of parties. So just refer to section 20. You can pause and read it. So section 20 states that no party in a contested divorce petition, collusion basically means that parties have come with a malified intention. They've come with a malified intention. already probably done some setting, or they've approached the court by concealing facts, etc. So, no collusion on their part, and a verification also has to be attached. Now, refer to section 21. It says that the CPC is applicable to divorce proceedings. So, I hope this part is clear till now. The jurisdiction part is clear. The divorce, the grounds for divorce part is clear. What is divorce? All of it is clear to you all. Now we'll be discussing the ancillary reliefs and interim application part. So, section 24, I'll take you to section 24. Also, this proceeding has to be conducted in camera and may not be printed or published. Now, bringing you to section 24. Now, so basically, section 24 talks about interim maintenance during pendency of litigation. You can ask for it in your petition. Then section for, so it's for spouse and children, and section 25 talks about, yeah, section 25 talks about permanent alimony and maintenance provisions. Section 26 talks about custody of children, their maintenance, their education. And section 27 deals with disposal of property. So, if any of your cases fit here, then please make sure you follow the guidelines which are stated in these sections. But in our case, we'll be understanding a simple divorce petition wherein these grounds are not there. We'll only be asking for interim maintenance and maintenance. So bring now this part is done, the provisions part. Now I'll be talking about, just refer to this legal note once. So this part I've dealt with the documents which are required. I'll tell you the procedure that's there. So, first, you need to keep your evidence ready, and you need to file the petition in proper court. So, these are the steps which are mentioned. Now, court will scrutinize your application, your petition, I'm sorry, and notices will be served to you. Now, you can take up mediation to resolve the issue. If mediation fails, then the court will continue with divorce proceedings, wherein both the parties will present their facts, evidence, witnesses will be, taken up by the judges. So cross examination is going to be done. And then, after final arguments and hearing both the parties, the verdict will be delivered by the court. Step 6 basically talks about the appeal part. So aggrieved parties can appeal to High Court with having jurisdiction over the family court, and later to Supreme Court within 3 months of passing of verdict. And court fees depends on the area where you're filing. This is for Delhi, so it's 15 rupees, but you can always check for your court. So we have covered the foundation part of it. Now I'll be taking you to how to draft a divorce petition. So we'll be discussing a template. Now we'll be moving to the second part of this session, which is 8 to 10 bulletproof tips on how to draft a contested divorce petition. So, for that, tip number 1 is, what all sections that you're referring to, make sure you keep them handy, make sure you've read them thoroughly from the Bare Act. You've touched upon every essential which has been mentioned in the Bare Act, and you've made small, quick notes for reference. Now, we are referring to cruelty as a ground of divorce for this particular session, and there's no definition which is given of cruelty as such in the section 13(1) IA. So we'll be referring to some Supreme Court judgments in order to understand that what all encompasses under cruelty. So cruelty can either be physical cruelty or mental cruelty. Now, so the words are pretty much self-explanatory, but I would want to touch upon mental cruelty too. That mental cruelty comprises of any emotional distress also which has been given, wherein it has become impossible for the spouse to live with dignity in this particular marriage. So, the courts earlier only recognized physical cruelty, but with time, they've also incorporated mental cruelty and recognized it as a part of cruelty. So, hurling abuses at wife or torturing or mentally harassing the wife also falls under mental cruelty. Asking for dowry, all of these things, they fall under cruelty. So Supreme Court has defined in this landmark case of Dastane versus Dastane, cruelty as a conduct that endangers the safety, health, and mental well being of spouse, which makes it impossible to live together. And the court emphasized that cruelty doesn't require physical violence, just physical violence, but persistent verbal abuse or humiliation can also suffice. Now, the scope of it was expanded in the case of Samar Ghosh versus Jaya Ghosh. And here, the Supreme Court added another set of list or guidelines for mental cruelty. And it said sustained unjustifiable conduct affecting physical or mental health, or false allegations of adultery, unchastity, refusal to cohabit or fulfill marital obligations without reason, public humiliation, all of these things were incorporated under this. So, why I touched upon cruelty was so that in our particular case, when we are drafting, or in the case which you're drafting, you can incorporate all of these keywords in your draft. So, let's now jump right to to the petition which I was talking about. And now, when you'll see this petition, you'll understand why I took so much of your time, why I took 15-20 minutes of this session to build your base. Because now it's going to be super easy for you. So, as my tip number one was that refer first to the Bare Act, see if there are any essentials which are there in the section and how they can be incorporated in your draft in order to make it rock solid. Make sure you use the terminology which has been used in the Bare Act. You try to add those words in your draft. And if there's nothing which has been mentioned which is very concrete, which defines the word, the particular ground which we are referring to, then go to Supreme Court judgments, use them, try to create a framework, a background in your mind, and then get heads on with drafting. So now you've understood that cruelty is not just physical cruelty, mental cruelty can also be incorporated in it. So let's now move on to the drafting part, and now you will be able to relate to it. So it'll all start with the jurisdiction part. Make sure you're referring to section 19. Make sure your jurisdiction is clear. You're clear on the jurisdiction part. Otherwise, it's going to get tough for you. So we'll start with writing in the court of principal judge. It's always presented before the principal judge, before any family court. So it's first going to go to the family court. If you're still not satisfied, you'll move to the high court. Again, if you're still not satisfied, you'll then appeal to the Supreme Court. So this is how the hierarchy goes. So in the court of principal judge, family court, and the jurisdiction. So for instance, you're referring to Patna High Court or to any other High Court, you'll mention the name of the place. So you'll write either Patna or you'll write New Delhi, or whatever your court is, just mention the jurisdiction. I've left it blank. Now, petition number dash of the particular year. So you'll leave this as dash because this is going to be given to you by the court. This number is going to be allotted by the court. Now we'll move to the cause title part. Now make sure the formatting which is there. So you align the formatting accordingly. So in the matter of and petitioner and respondent, this is going to be aligned towards the right. So you'll write the name of your client, Mr. or Mrs. can depend. Then you'll write the age, and you'll write son of or daughter of in the father's name and the complete address. Versus same manner you'll do it for the respondent. Then you will add the subject of the petition. So the subject is petition for dissolution of marriage. Under, you'll clearly mention the section and the name of the act here. Now we'll move on to the main part. Now again, this particular petition which I am talking about right now, so this is just to make you understand that how it's drafted. It's a rough template, and I'm also going to show you an actual divorce petition by the end of it. But if I'll show you an actual drafted petition, you'll get confused. So that is why first I want to build your basics, and then we'll go to an actual petition, and then I'm going to tell you what all needs to be done. So just understand very clearly from this that what the structure is, how the formatting is, and then we'll implement it in the actual petition. So you'll start by most respectfully show it, and then you'll mention that the petitioner, the religion of the petitioner is Hindu, and they have been residing within the jurisdiction of the Honorable Court. So you'll clear out the jurisdiction part, the religion part, and the respondent is also Hindu by religion. The Hindu Marriage Act is only applicable if both the parties are Hindu in this case. Now, the marriage, where was it solemnized? And you'll mention the date, the place, but very briefly. And now you will say that it was according to Hindu rites and ceremonies. Why are we saying that? Because it is an essential thing under Section 7 of the Hindu Marriage Act. And the marriage was duly registered under the HMA Act. So you'll, in the first para, you'll clear out your religion, the jurisdiction of the court. In the second point, you'll start giving details about the marriage. In the third part, you'll tell that where all you resided, your residential history, to further clear out the jurisdiction part. And if there are any children, do mention about them too. Here, so third point is the part where you need to mention all of it. Now, you'll now start from fourth point onwards. You'll start narrating your story, that how the respondent was torturing you, how the respondent was basically doing cruelty against you. So you'll start narrating your story. You'll add specific incidents with dates and details. Don't add a lot of details, that it's don't add unnecessary details is what I want to tell you here. Now look at the kind of words that I've used. Consistently, which means that it has become, now the environment has become so hostile because I've been regularly, on a regular basis, subjected to abusive language, derogatory remarks by whomsoever in your case. And you'll say that there's constant emotional harassment, or you can also add physical abuse, etc. And it has created a hostile environment at home, making it impossible for the petitioner to live peacefully. So look at the kind of words that have been used: hostile environment, irretrievable damage of marriage. You can also refer to that. You can also add that. It has become hostile at home. It has become impossible to reside together. Now you will say that now you'll tell what all efforts from your end you've taken. So you've done reconciliation, you've tried for counseling, but nothing has worked. And the marriage has irretrievably broken down. And irretrievably means it cannot be retrieved, it cannot be brought back, it can't be sorted. So now you'll just further try to clear out your point, and then you'll say that you try to substantiate all of these points with relevant case laws, relevant statutes, relevant judgments, and then you'll say that the present petition is filed under the ground of cruelty under this particular section, and it has become impossible to continue this relationship. Also, the parties have come with clean hands. They haven't colluded, as mentioned in this point. If you remember, we referred to section 20. Section 20 talked about collusion. So look how everything is now getting applied here. Also, in the 10th point, you will just clear out the jurisdiction part even further and say that it is solemnized within the jurisdiction of court, or wherever whatever the essentials, any of these 3 points can be written. If all of three are same, you can mention that it has been solemnized, or we have been living together, or the last matrimonial home was this. So you can mention any of those things, or if all of them are applicable, and just say that the honorable court has jurisdiction to entertain and try it. Now you'll start writing your prayer. So you'll start by saying, pass a decree of divorce, the most important thing which we are praying for, the most important relief which we are praying for. You can then add for equitable division of matrimonial property. You can add for now in this particular draft, I haven't mentioned, but then you can also ask for interim maintenance. You can even talk about permanent alimony and maintenance, and then you will leave room open for court to grant any relief which it deems fit and proper. Place where it has been filed, date, now the verification, and it has to be supported by an affidavit. Now don't be boggled by all of these terms. Don't worry, we'll be referring to an actual petition now, wherein I'll be talking about what all I've taught you right now. We'll see how it is getting applied in an actual template, in an actual real life divorce petition. Please note, I've changed the name of the parties, I've changed their address in order to maintain confidentiality. So now let's jump directly to that. So this is the actual draft, and I'll now be telling you the tips which need to be followed. So, first tip, I hope you remember, is identifying the ground of divorce, then referring to the Bare Act or Supreme Court judgments if required, or any High Court judgments or relevant courts judgments in your present case, to understand the definition of that ground of divorce, what all it encompasses, and try to incorporate it in the draft. Now, second point, which is to make sure the jurisdiction is right. So tip number 2 is to refer to section 19, and here the jurisdiction in the present case is Patna High Court. Now, tip number 3 for today is that if now when you have figured out the jurisdiction, now you will actually start drafting, and make sure you mention the correct details of the parties in correct manner. So name of the party, gender if required, if you want to add, age, father's name, their address, and you'll also demarcate the party which is there. So it's either the petitioner or opposite party, you'll tell. Then you'll give a crisp subject to the petition, which is dissolution of marriage, wherein you'll clearly state the ground and the act under which you're going. Tip number 3 is going to be that I think it's tip number 4. So tip number 4 is going to be clearly mention all the facts, mention the religion of the parties, where marriage was solemnized, whether it's registered or not, where the party was living, and is there any child which is born out of the wedlock or not, and where the child is living, with which party is the child living right now, have the parties separated, give all the details, relevant details in a crisp manner. So I've given the details. Now, tip number 4, add annexures wherever you deem fit, deem necessary, add annexures. And how will you add annexures? You'll align it slightly towards the right, and you just say that a photocopy or a copy of the particular document is is herein annexed and attached or marked as annexure 1, or whatever number you want to give to this particular petition. Now from the 4th point onwards, you're going to start with your story, with how cruelty occurred with you. So the first 2 3 points are going to be about the details of your marriage. Now from point 4 onwards, you're going to narrate your story, how cruelty happened to you. Tip number 5, always substantiate it with judgments. And whenever you're referring to judgments, you add the full citation of it. You add it in this manner, in bold and italics. You can not add it in italics, it's fine, but then make it bold. Then you'll also tell the para of the judgment which you're referring, which is relevant here. You're going to copy paste the para in inverted commas and italics. Whenever you're copy pasting anything, make sure you're doing it in italics. So wherever I've made a point, I've added a judgment. You can see the judgment with relevant para number and paragraph reproduced here for the court's convenience. Now, from ninth para onwards, you start making your points that now, because of all of these, all of these things which I've mentioned before, and because of these judgments which I've added to strengthen my point, it has become tough to live together. It has become impossible to live together. And then you start to substantiate a bit on it. So again, you can add judgments wherever you feel there's a need for it. Now, as mentioned, that residing under the same roof has become devoid of any mutual companionship, love, or basically the things for which we marry. It is just now it's no more there. It's now futile to cohabit together. It has become difficult to cohabit together. And point number 6 is that now you'll clear out your part that we have not previously instituted any matrimonial proceeding, or if you've instituted, then give details of that too, and say that to the best of my knowledge and belief. And now you'll say that now you'll further clarify the jurisdiction part here. So point number 7 is you're going to give the reason again for why you're filing the case in this court. So you can say that we resided here, etc., etc. Point number 7 is going to be you're referring to section 20 again. You're circling back to it, mentioning you're not filing it with any collusion, connivance, undue influence. It's bona fide and good faith. Now you'll then mention and ask for a decree of divorce. You'll also say that we have paid the court fees, and then in the so again, point number 8, the tip number 8 is going to be to ask for as many reliefs as you can under the roof, and valid reliefs as many as you can, and then to leave room open for court to grant any release which it deems fit. point number, I've just lost count of the number of tips that I've given. So the second last tip is going to be to attach verification and state. So the petitioner has to state that from para 1 to dash 2, you can just mention the till the last para before the prayer are true and best to to my knowledge. And so this is how a verification is made. You can copy paste the format and change the details. Then you will also add tip number 10, I'm assuming, an affidavit, and you'll place the Aadhaar card copy front and back on the next page. So you'll paste, you'll add the Aadhaar card copy, and then in the last you'll add index, and you'll also here add the list of annexures which you've referred to. I've just mentioned the first annexure details. You can just get an idea from here. And then you can also, you will mandatorily also have to file a wakalatnama. So this is how it is done. And this is the end of this masterclass on how to draft a contested divorce petition. Thank you.